Oregon has some of the most restrictive lease termination laws in the entire country, and they've been significantly tightened in recent years. If you manage rental property in Oregon, you absolutely must stay current on these rules because the consequences of getting it wrong are severe. Oregon's lease termination framework is found in the Oregon Residential Landlord and Tenant Act, Oregon Revised Statutes Chapter 90. In 2019, Oregon made national headlines by becoming the first state in the country to enact statewide rent control and mandatory just cause eviction protections through Senate Bill 608. These reforms fundamentally changed how landlords can terminate tenancies in Oregon. Let's start with the biggest change: just cause eviction. Under Oregon law, once a tenant has occupied the unit for 12 months or more, the landlord can only terminate the tenancy for specific reasons listed in the statute. You cannot simply give a no-cause notice to a tenant who has been there for a year or longer. The qualifying reasons for termination include non-payment of rent, material lease violations, the landlord's intent to personally occupy the unit, the landlord's intent to demolish or make major renovations that require the unit to be vacant, the sale of the property to a buyer who intends to occupy the unit, and certain other specific grounds. For tenants who have been in the unit for less than 12 months, the landlord can still issue a no-cause termination notice, but the notice period is 30 days. And during the first year, the landlord must provide a written reason if the tenant requests one within 6 months after the termination takes effect. For month-to-month tenancies, where the tenant has been in the unit 12 months or more, the landlord must have just cause and must provide at least 90 days written notice for no-fault terminations, meaning situations where the termination isn't based on the tenant's behavior, like owner move-in or major renovation. That 90-day notice is one of the longest in the nation. Here's the other major piece: relocation assistance. For no-fault terminations of tenants who have been in the unit 12 months or more, the landlord must pay the tenant 1 month's rent as relocation assistance. This payment must be made within the notice period, and failure to pay it can invalidate the termination notice entirely. Some Oregon cities, particularly Portland, require even higher relocation payments under local ordinances. For fixed-term leases, the lease expires at the end of the agreed term. However, Oregon requires the landlord to offer the tenant a renewal on substantially similar terms, unless the landlord has a qualifying just cause reason not to renew. This means you can't simply let the lease expire and refuse to renew without cause once the tenant has been there 12 months or more. Now let's cover termination for cause. For non-payment of rent, Oregon underwent significant changes. The landlord must provide a written notice giving the tenant at least 10 days to pay before the landlord can proceed with termination. If the tenant pays the full amount within that window, the tenancy continues. If the tenant doesn't pay, the landlord can then issue a 72-hour notice to vacate and proceed with filing for eviction. Oregon also requires landlords to include specific information in non-payment notices, including the amount owed, the deadline for payment, and information about rental assistance resources. Failure to include this required information can invalidate the notice. For material lease violations, Oregon uses a 14-day notice to cure, followed by a 30-day termination. The landlord must provide written notice specifying the violation and giving the tenant 14 days to correct it. If the tenant cures, the notice is void. If the tenant doesn't cure within 14 days, the tenancy terminates at the 30-day mark. For repeated violations of the same type within a 12-month period, Oregon allows the landlord to issue a subsequent notice without providing another opportunity to cure after the second occurrence. On the third occurrence, the landlord can proceed with a 10-day notice to vacate. For serious violations, including criminal activity, drug manufacturing, acts of violence or threats against other tenants, and intentional substantial damage to the property, Oregon allows a 24-hour notice to vacate with no opportunity to cure. This is the fastest termination pathway in Oregon and is reserved for the most severe situations. The landlord must be able to demonstrate that the conduct actually occurred, and courts will scrutinize these notices carefully. Oregon also has specific provisions for perpetual nuisance behavior. If a tenant's conduct, or the conduct of the tenant's guests, creates a serious and ongoing disturbance that substantially interferes with other tenants' right to quiet enjoyment, the landlord can issue a 30-day notice after documenting the pattern of behavior. Portland deserves special mention because the city has its own additional tenant protection ordinances that go beyond state law. Portland's relocation assistance requirements are more generous, requiring landlords to pay the equivalent of 3 months' rent for no-fault terminations in certain circumstances. Portland also has additional screening and notice requirements that landlords must follow. On the tenant side, Oregon provides robust grounds for early termination. Tenants who are victims of domestic violence, sexual assault, or stalking can terminate the lease early by providing written notice at least 14 days before the termination date. The tenant must include documentation such as a valid protective order, a police report, or a statement from a qualified professional. The landlord cannot charge early termination fees, retain the security deposit for early termination, or report the early termination as negative rental history. Oregon also provides early termination rights for tenants aged 62 and older who need to enter a care facility, and for tenants whose only household member has died during the tenancy. In the case of a deceased sole tenant, the estate or a family member can terminate with 14 days' notice. Tenants can terminate if the landlord fails to maintain the property. As we covered in our Oregon habitability video, for essential services failures, the landlord has 7 days to make the repair. If they don't, the tenant can terminate. For non-essential repairs, the window is 30 days. Active duty military members are covered by the Service Members Civil Relief Act with 30 days' notice following deployment or permanent change of station orders. Oregon strictly prohibits self-help evictions. Under ORS 90.375, landlords cannot change locks, shut off utilities, remove the tenant's belongings, or take any action to force a tenant out without going through the court process. The penalties are significant. The tenant can recover up to 2 months' rent or twice actual damages, whichever is greater, plus attorney's fees. Oregon courts enforce these provisions aggressively. The eviction process in Oregon goes through circuit court. The landlord files a complaint for forcible entry and detainer, and the court schedules a first appearance, typically within 7 to 14 days. Oregon's eviction process has become more complex in recent years, due to legislative changes that added procedural requirements and extended timelines. Contested cases can take several weeks to several months, depending on the defenses raised and the court's caseload. Oregon requires landlords to return the security deposit within 31 days of the tenant vacating the property. The landlord must provide an itemized accounting of any deductions. If the landlord fails to return the deposit or provide the accounting within 31 days, they may be liable for up to twice the amount of the deposit. For the complete guide to Oregon lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel so you stay compliant in every state.